Yeah, very good evening to chairperson as well as the lead speaker and all the delegates and Dr. Kamodar. And I, on behalf of TNNLU community and the All India Legal History Congress Organizing Committee, I extend a warm welcome to each and every one of you. Here, I'm very happy to introduce our chairpersons and followed by our lead speaker. So our chairperson, Professor Julia Stephen, who is as an associate professor of history at the State University of New Jersey. And she formerly worked at the State University of the Yale University as an assistant professor between 2014 to 2016. And again, she was already served in the Center for History and Economics, Cambridge University between 2013 and 2014. And she successfully completed her PhD from Harvard University. Members, am I audible?
Yes, you're audible, very audible.
Thank you. And for the Professor Julia Stephen, she completed her MPhil course at Trinity College. There are so many publications she successfully published. And with this, some few noted publications, it's my privilege to tell out to the August gathering. In Progress, Worldly Afterlives, Tracing the Roots of India's Global Diasporas, under contract with Princeton University Press. And another one, Governing Islam, Law, Empire, and Secularism in South Asia, Cambridge, published by Cambridge University Press. And Legal History Between the Humanities and Social Science, Comparative Studies of South Asia, Africa, and the Middle East, which was published in 2019. And I'm very glad to inform in this August gathering that, and she's subject expert in teaching that following courses like Making of Modern India and Pakistan, Political Islam, Present and Past, Family History, Migration, World History from Below, etc. And Professor Julia Stephen received around 14 fellowships and awards. It's a great success in her academic career. Among these 14 fellowships and awards, I request all the delegates to mute your call, mute your audio. Thank you. So among these 14 fellowships, I'm very happy to tell out one or two here. Humanities Plus Pedagogical Innovation Grant in the year 2020. Inter-Asia Fellowship Social Science Research Council in the year 2016 to 2017. And from very beginning in the year 2005 to 6, she received Henry Fellowship for Postgraduate Study at Cambridge University. With this very brief academic contribution, I wholeheartedly welcome Julia Stephen to this August gathering. Welcome, Professor.
Thank you so much for that generous introduction. I'm really excited to be here today.
So followed by, I'm very happy to give a warm welcome to our lead speaker, Professor Kalyani Ramnan. Professor Kalyani Ramnan is a lawyer and historian of modern South Asia with research and teaching interest in legal history, histories of migration and displacement, transitional history, and questions of archival method. Her book project boards in Nostrum, Law, Migration, and Decolonialization in South and Southeast Asia, 1942 to 1962, focus on post-war legal struggles that connect South and Southeast Asia, and its implication for citizenship and statelessness struggles today. She received her PhD degree from Princeton University in the year 2018 and also holds a bachelor degree in arts and law, BA LLB honors from NLISU Bangalore, and master degree in law from Yale Law School. From 2010 to 2012, she served as a faculty of NLISU Bangalore. Her work has been supported by the American Historical Association, the Princeton Institute for International and Regional Studies, the American Institute for Sri Lankan Studies, and the Hart Fellowship for Tamil Studies. She was elected to the Fellowship of Woodrow Wilson Scholars at Princeton University to 2016, was a fellow at the Hearst Institute for Legal History at University of Wisconsin-Madison in 2017. And she participated in the Social Science Research Council Inter-Asia Academy in 2021. Her work has been published in the Indian Economic and Social History Review, Journal of Indian Law and Society, Law and History Review, and Interview, a journal of imperial and global interactions. With this brief academic contribution, I wholeheartedly welcome Professor Kalyani Ramnan to provide the lead paper. Thank you, ma'am, and welcome both of you. So now I hand over the session to our chairperson, Professor Julia Stephen.
Thank you very much, Julie. Julie, did you?
Yeah, it's. I think it's okay if you go ahead and start, and
Okay.
yeah, you can share your screen.
Yeah, no, absolutely. All right. So thank you, Professor Stalin, for that very, very generous introduction and for this invitation to present at the second All India Legal History Congress. I was just mentioning before you started your sort of remarks that I began my journey as a legal historian as a student in Professor Elizabeth's class, and served as a teaching assistant for 2 years. So that's really where I began. So it's a particular joy to be here and to share my work today. So my talk today is titled Legal Histories and Affective Geographies Across the Bay of Bengal. And really I was thinking about what would be most useful for this gathering. And so this is a brief reflection about researching and writing a legal history beyond the territorial boundaries of India. India, as we know, often stands in for South Asia. And this is really just an invitation for all of us to just think about what it means to be challenging that assumption. What if we were to think of South Asia beyond India? And what does that mean? What are the challenges, etc.? That's what I will be focusing on today. My own work and my book project draws extensively from archives and materials from Madras and the Madras High Court to understand migration and mobility from India. And I want to share some of those examples today as well. So I'll briefly speak on 3 interrelated topics. First, on the process of reading and researching legal historical materials in and from the Madras High Court. Second, I want to discuss an example of some of those materials that I looked at in the court's archives that prompted me to think of Madras not only as a part of British India, but as part of a South Asian legal history. And third, I want to conclude with some brief notes on opportunities and challenges that one might face in thinking about legal histories beyond the nation state, particularly in South Asia. So first, to reading and researching legal historical sources. So on a sunny afternoon in 2015, I turned up at the record section of the Madras High Court. I placed the permissions that I had secured from the court's Registrar General and my own credentials as a lawyer on the table before the official at the main desk. And I told him I wanted to look at case papers and case bundles from the 1940s for a research project on the legal struggles of migrants from peninsular India to present-day Sri Lanka, Singapore, Myanmar, and their displacement following the rapid post-World War II collapse of the British Empire in South Asia. This was supposed to be my research project. I wanted to get hold of some archival materials from the court. After a lengthy interrogation and strident denials that the said bundles existed, the official conceded the possibility that they did. But he told me, "Are you sure you want to go in there? It looks like it looks like a dungeon. You might have trouble getting in there." So he gave me this very strong warning. So after much persuasion, I stood outside a grilled shutter that barred access to what appeared to be a parking lot. Inside, a steep incline led down to a large space with nearly 200 parking spots. The white lines that formed the boundaries between the parking spots had faded and were overlaid with a thick layer of dust. A sunroof in the middle of the lot was the only source of natural light, and it let in snatches of conversation from the lawyers' offices upstairs. Colonial era furniture, broken judges' chairs, partially dismantled witness boxes, typist tables, etc., littered the area. Case bundles were everywhere, tied together with fraying white thread that is a staple in Indian government offices. They were on the makeshift book racks, the abandoned furniture, and on the cemented floor. They appeared to have been half-hearted attempts to organize the material, but they had been abandoned, perhaps by a worker or the officer in the record section, frustrated by the magnitude of the task before her. The cover sheets noting the names, and this will be familiar to lawyers and law students, the cover sheet of the case bundles that had the names, the case numbers, and administrative details relating to the case were missing on most of the bundles. As a result, staff members had searched haphazardly, leaving bundles untied and cover sheets untorn. At the very back of the lot, there were two rooms. Picking bundles at random in one of the rooms, I noticed the beautiful cursive writing of old judgments written out by hand. The name at the very top was Thomas Strange, the first Chief Justice of the Supreme Court at Madras from 1801 to 1817, the court established in Madras after the Fourth Anglo-Mysore War. Other bundles were newer by comparison, but there was no method to this madness. This was only one of 9 go-downs that formed the extended record room of the Madras High Court. In 2015, when I first visited the court's archives, there were in excess of 200,000 cases filed under each category of the court's jurisdiction. I give this description, not to pathologize the state of archival material in India, but to really point out that this is the material that we work with as legal historians of India. This is our archive. It is disassembled, dispersed, and visually overwhelming. And this is what I had to confront as I began my project on the place of law in post-World War II South Asia. From the perspective of legal professionals, the record rooms are not traditionally structured repositories, nor are they solely collections of legal matters in which the government is a party. They are not intended to be repositories of memory or embodiments of heritage. They form part of the administrative section of the High Court as opposed to the judicial section, with which historical narratives are more familiar. So we work often with judgments, but not really with this part of the court, right? The record room is a living, working part of the court's infrastructure, assembled primarily to assist judges, lawyers, and law clerks in the preparation of briefs, compilations consisting of arguments in support of a particular party to the case. Contrast this with the national or state archives that contain proceedings of government departments or ministries to which records are added at intervals of time and achieve a degree of finality. Cases from any time period may be called forth from the record room at any time in support of a new argument that somebody wants to make before the court, or if the judges themselves want to consult some of the older rulings on a legal issue. This calling up of records is not unusual. Rather, the nature of common law judicial practice rests on it. And I want to mention this and discuss this in wanted to discuss this in some detail because as lawyers and law students, we often only deal with the end product of this case, right? I mean, we look at the judgments and we sort of build our legal histories around that. But really the treasure trove is in looking at, how the court functions, how this judicial institution shapes the paper material that we work with and we love to work with as legal historians. But there should, and really in the talk, I want to give to sort of highlight why we should take that sort of legal procedure seriously. Court records are not, of course, the only kind of legal historical sources, although there are rich descriptions and details in case files and case bundles that you might not find in a set of rules and regulations. I wanted to mention Mitra Sharafi's work with judges' notebooks in the Bombay High Court, Rohit D's history of litigation at Supreme Court around the Indian Constitution, Cynthia Farid worked with legal records from Calcutta and Dhaka, Uttara Shastri and Madras Kapoor, who worked with legal materials from India, Pakistan, and Bangladesh, to mention a few scholars who trained both as lawyers and as historians, who are thinking about legal histories of South Asia that are beyond India. But back to my story. Madras is a critical entry point for the study of legal, economic, and social histories of South and Southeast Asia. By 1682, Madras had replaced Bantam in present-day Indonesia as the eastern headquarters of the English East India Company trade. Although it becomes less important as a trading center than Calcutta and Bombay over the next century and a half, between the 1840s and the 1940s, it became an important point of departure for indentured laborers and intrepid traders as they departed the Coromandel coast to seek fortunes further east to Sri Lanka, Myanmar, Malaysia, Singapore, and beyond. In 1942, when Japanese forces occupied Burma, or present-day Myanmar, circular migrations around the Bay of Bengal littoral decreased in intensity and frequency. But it is here that I begin my own book. The everyday work of the Madras High Court, some of which I wanted to sort of capture through my description of the archives from which I wrote those histories, reflects the important role that this coast and its hinterland played in labor, capital, and credit networks around the Indian Ocean. One such mobile network was that of the Natukottai Chettiars, a diasporic trading community that ventured from the Coromandel Coast as far as French Cochin China, including parts of present-day Vietnam, beginning in the 16th and 17th centuries. Community legend has it that a community of Natukottai Chettiars were granted land by the Pandya king in the Ramnad and Shivaganga districts of Madras when their traditional homelands on the banks of the Kaveri River were submerged due to a flood. Their fortunes grew as salt and grain traders, gem merchants, and money lenders. They cemented their political and social power by making charitable contributions to local temples and by lending money on the strength of landed collateral to local zamindars in these districts. As the samasthanams or kingdoms of these districts were unable to pay back loans, they were forced to give up landed property. Sometimes entire villages which formed part of the samasthanam were pledged as collateral and would be turned over to Chettiar moneylenders. So the moneylenders themselves took to the law courts as a means of recovering these debts. They were so successful that by 1896, Devakotai was constituted, one of the Chettiar villages in Ramnad was constituted separately as a zamindari, cementing the place of the Natukottai Chettiars as powerful notables in the region. I was told by practicing lawyers at the Madras High Court that there would be abundant evidence in the record room to Chettiar litigiousness. So this turned out to be true. Amongst the case bundles that I came across in the record room, one involved Mayammayachi, a woman who fought a long drawn-out battle against her husband Raman Chettiar and her son-in-law Annamalai Chettiar. When she discovered that her wealth had been ill invested and was possibly being spirited away, she filed a suit at the local civil court in Shivagangai for a declaration of title. So you know what a declaration of title is. I don't need to explain to this audience. This is to prove that her lands and her house belong to her and no one else. When the initial verdict went against her, she appealed to the Madras High Court. And once the appeal was filed, all the papers relating to the lower court decision were collated and brought before the High Court. Presumably, once the decision in the High Court was handed down and the case was closed, these papers became part of the record room. And this is how I find these materials in the Madras High Court. This case bundle in appeal number 321 of 1942 included a printed set of materials relating to the case, the original plaint filed by Mayammayachi's lawyer at the subordinate judge's court, the written statement, and you can see all of the list, what was constituted in that case bundle here. At first glance, this looks straightforward enough. right? I mean, this is a set of materials from which one can write a number of different a number of different legal histories. One that talks about historical agency. It could be about women in the law. It could be a history of the family. It could be a story about caste and gender. It could be a story about property regimes. You name it, there is potential here. But I was not perhaps, I mean, and this is a story that I perhaps expected to see. What I did not expect to see was how these case papers documented the flow of capital and credit beyond the borders of British India. If archives present us with an infinite number of relations to reality, to use Arlette Farge's phrase, then we might read this legal encounter not only as quote unquote evidence for any of the above, caste, gender, property, etc., but also as an opportunity to explore and imagine how and why people make legal claims. As we recall, Mayamai Achi had claimed that the properties were bought and the house was constructed with her own Stridhanam. However, here the plot thickened. Her husband Raman was indebted to her son-in-law Annamalai, and Annamalai claimed before the court that his in-laws were colluding and plotting against him to prevent him from recovering his debt. What appears at first to be a case about a woman appearing in her own right as a litigant, a property owner, and investor before the court is more complicated once we take legal procedure seriously. So the judge at the Chivagangai court did not believe Mayamai's testimony that the properties were only in her husband's name because she was a woman. And so the judge writes, it is not as if she was a young girl when these sale deeds were brought about. He wrote, calculating she would have been about 33 years old when the first of the properties were bought, surely old enough to conduct her own business. Producing account books before the court, Mayamai and her lawyers claimed that her Stridhanam was invested in Chettiar money lending firms in Burma beginning in 1896, and that this had continued until 1937. Once again, the judge claimed that while she was certainly immensely wealthy, there was no quote-unquote custom amongst Chettiars that land had to be purchased in the name of a husband for a wife. All documents, including sale deeds and tax receipts without a single exception, were in the name of the husband. There was no proof that the house she lived in was her own property. In court, Mayamai claimed that her father-in-law had a money lending firm in Ceylon, but that her husband was not involved in it. Her husband had traveled to Rangoon as an agent for another money lending firm, but had not been paid. This was not unusual. Men were often treated as apprentices, not employees in their own family firms. Her son had traveled to Kuala Lumpur as an agent of another firm, but again, no money had come to the family. It is possible that her son was also apprenticed to another firm. Even if he had received funds, this would have been for his own use, according to Chettiar practice. So effectively, Mayamai Achi was making these claims before the court to claim that all of the money that she had received as quote unquote bride price for her three daughters were used to conduct their marriages, including that of her daughter with Annamalai. In the end, Mayamai's personal narration did not match up to the official histories of sale deeds, hypothecation deeds, tax receipts, and account books that supposedly captured the travels of her own wealth. Curiously and somehow paradoxically, all throughout her trial, her husband Raman was noted as being ex parte, not present and not heard. Included in the case papers was a list of documents produced in the High Court from 1889 to 1940. From 1908 to 1937, Mayamai Achi's lawyers were able to construct a steady source of income by way of interest from firms in Rangoon, Pesolak, and Wakema. These are all places in Burma. This is one more instance of creating a personalized history, and we might be tempted to go back and create an organized topography from documentary exhibits placed before the court. But this ordering of Mayamai's life as a series of debits made and credits accrued to her Stridhanam account also speaks to the intertwining of legal and political temporalities. 1937 as the end of this paper trail is significant, for this is the year of the partition of Burma from India and its constitution as a separate crown colony of the British Empire. In other pending litigation at the Madras High Court, Annamalai had first filed suit against Raman in 1937. This timing too is significant. As early as the mid-19th century, Natukota Chettiars had begun to use litigation as political strategy. As David Radha shows, Chettiar firms, even those that were not located in Burma but had their investments there, suffered significantly as Burma was partitioned and cross-border transactions became more expensive. It would appear that as late as 1942, when this particular appeal was filed, when the Japanese occupation of Burma dealt a crushing blow to Indian commercial interests in India, the after effects of the first partition of the Indian Empire was still being relived in courts in Madras. These cases are still retained in the record room at Madras High Court with the potential to shape. Apart from the rich treasure trove of legal historical sources that we can work with and the stories beyond India that we might tell from these records, I hope this description makes abundantly clear that, as with other subfields, reading and writing legal history is not a lonely scholarly endeavor, but must include librarians, archivists, and the legal profession. It might be produced in a number of different genres, essays, and so on. So we'll talk more about that in the discussion. I might request whoever has their call unmuted to please mute the call, because I don't think it can be audible otherwise.
I think also that Professor Stalin, as the host, you may be able to mute people if they're having some trouble with the technology.
Yeah. I think it looks all good.
She's very clear.
Participants, please switch off your mic. Otherwise, we will expel you from this session.
You might
Participant,
be able to mute them, Professor Stalin. You might be able to just mute them since you're the host. But I'll continue. If it gets too
yes,
complicated,
Professor. Yes,
I'll
Professor. I will inform the IT support.
No,
You
don't
please
worry.
go ahead.
Sure. So I just wanted to use the example of the Mayamayachi appeal and its archive at the Madras High Court, so that we could talk a little bit about what the potential is, and it's just a brief suggestion to think about how legal histories map affective geographies. And by affective geographies here, I mean familial, cultural, or sacred geographies that were formed by those who moved or those who were forced to move around the Bay of Bengal, that don't map onto the ways in which we understand the territorial boundaries in South Asia today. And this is just an invitation for us to think about a legal history of India of South Asia that's not centered on India. Key to such a project, and this is perhaps something that might be useful for our conversation as well, is to look at how law circulates. Here, law is not just doctrine, rules, and regulations, but also practice. It is lawyers, litigants, and notaries. It's artifacts and ephemera, including textbooks and law reporters. In a piece published last year in the Law and History Review, I discuss once again through a set of case papers involving the Chettiars, how law travels and why. So in that particular article, what I was looking at was another debt recovery case that involved a Chettiar money lending firm that had offices both in Madras and in Rangoon, and their transactions during the Japanese occupation of Burma. As some of you might know, during the Japanese occupation of Burma, the legal tender was different. It was not the British Burma rupee, but it was occupation currency. So debts between Chettiar's firms were made in that occupation currency. So once the war ended, the question became, was that money legal tender? What do we do with all of these contracts that were concluded during the war? And this became a big part of litigation at the Madras High Court, but also courts across South and Southeast Asia. So that is a case that I discuss in this article that I published last year. And it's really quite fascinating because it uses the language of international law. And international law at this particular juncture is really interesting because this is the time in the late 1940s as nation states are coming into being in South Asia. So India is now distinct from Burma, which is distinct from Sri Lanka, where earlier it was all part of the British Empire, and there was a lot more intense circulation between these places. But what I was trying to do in this particular article is trace through footnotes. And as lawyers, we understand the importance of precedent and citational practice. And what I was doing in this article was to try and trace through a footnote small debt recovery case ends up in an international law textbook written in Europe in the 1960s. Even though the primary litigant in that case, who was again a Chettiar woman, had never left Madras. So the person is stationary, the case is local, but somehow the doctrine and the law and the case situation ends up in Europe. So how does that work? And what does that tell us about how we might write a legal history that is not bound by territorial nation states? So the international law textbook, as it turns out, was written by a prominent jurist who had fed information to the Dutch government in exile during World War II and was commissioned to travel to Batavia, which is present-day Jakarta, to participate in the negotiations between the Dutch colonial government and the leaders of Republic Indonesia. In this article, I also talk a little bit about the role of the Madras Study Group on International Law, of which the prominent historian of South India, K.A. Nilakanta Shastri, played a role, and how the Ford Foundation funded initiatives to popularize the study of international law in India. Even though none of this had anything to do with the primary litigant in that case, who was a Chettiar woman who was simply trying to get her debts back. And to sort of reinstate some of the credit networks that once connected in Madras and Burma. So what I want to suggest through all of these examples is that there is rich potential here for us to think about writing history at multiple scales, at the global scale, at the regional scale, but certainly one that does not have to take the nation state as the primary unit of analysis. Why is such a legal history important? It forces us to examine the assumptions in which history is often perceived as being tied to the fortunes of the nation state or a particular form of nationalism. But the point at which these questions need to be examined are not necessarily to go back to a cosmopolitan past or a romanticized sort of proto-globalization, by which I mean that we don't necessarily have to say, look, there was a past in which these nation state borders didn't exist, and that was the good sort of world, and this isn't. This is often the default mode in which we think about maritime histories of South Asia. But instead, I suggest that it's important to explore why these divisions occurred. In my case, how the history of South Asia often centers India without reference to Sri Lanka, for example, or how South Asia is written without reference to Southeast Asia. Instead, let's think about how these divisions occurred. And in my story, it's because of the Second World War that South Asia and Southeast Asia are seen as different units. And such a legal history, I suggest, is important because it centers how people thought of these worlds as being connected, as linked, and how this is what I mean by an affective geography. Julie, my last point. This sort of history, this sort of legal history, is not without its challenges because of India's place in South Asia, which is hegemonic. It might be easy for you to imagine that discussing the plight of wealthy landowners widely believed to have been responsible for the downfall of a Burmese peasant class would be received differently in India than in Burma. Or the plight of plantation laborers rendered stateless received differently in India than it is in Sri Lanka. None of this work also exists outside the political economy of funding for research, travel, and language training, and the privilege of acquiring passports and visas to follow our historical actors across borders. But here I suggest lies the potential for us to think about imaginative ways in which we might read, write, and research legal history that questions how borders, territorial, juridical, scholarly, and regional, were made even as we attempt to transcend them. And I will stop there. And I'm really looking forward to the rest of the presentations. Thank you.
Thank you so much, Professor Ramnath, for that really wonderful sort of start to our discussion. So I think I'm going to quickly move on to the next paper by Dr. Johnson, the director of the Maritime History Society, Mumbai. And the title of the presentation is Maritime Security Framework, Evolution of India's Legislative Approach. And I'll try to be a little bit more strict about keeping time so that we can sort of keep the session within the bounds. So thank you.
Thank you, Professor Julia. I assure you I'll keep time. So, respected chairperson, Dr. Julia Stephens, lead speaker and a pioneer in the subject, Professor Kalyani Ramnath, and my fellow panelists, greetings from Maritime History Society. I recognize what the Chancellor of the University and Chief Justice, His Lordship, Justice Banerjee, made an emphasis on the need for both precedents and jurisprudence. I'm also encouraged by Professor Anthony Masson's concise focus on a multidisciplinary and, may I dare to say, a non-lawyer, non-historical contribution to the growing field of legal history. As someone who was part of the pioneering gang of crazies on the first All India Legal History Congress, please allow this sanity-challenged seafarer's attempt at scholarship, because there is no other paper on the maritime dimension in the entire, and I was very happy to hear Professor Kalyani at least allude to maritime history in the closing part. So thank you for that. In the remaining few minutes, allow me to give a quick context to maritime security framework in the evolution of India's legislative evolution. And I have been helped greatly by a number of resources, which are there, of course, in the bibliography, and my own research team. I have a lovely bunch of supportive scholars. Very quickly, I'm going to just refer to something. We must look at the concept of freedom of seas. Here is my version of effective geography. The very background and doctrine of the theory of natural law comes quite often. We talk of, Hugo Grotius's Mar Liberum, and he says this so beautifully: it would be an intolerant outreach for anyone to sneak away, even if he could do so from public, the use of the larger area of the seas. And so, in current understanding, there is a multilateral order with governance and good order at sea as an evolving process. Sea today is the means of survival to the planet, with potential risk to marine ecology and global economy. So I will actually close with this point right in the beginning. A collaborative approach towards free and open seas for sustainable development is required, and he agree it is Marin who will advocate for concepts and precepts beyond the nation states. Quick look, no explanation. This is India's maritime interests and geographies. And we would want to look at this. I'm skipping, except for K.M. Panikar says it is a geographical position of India. And I'm talking now of the landmass geography of India, the one which started in the Paleolithic age and actually crashed into the Eurasian landmass. I call it a forever island India. So, in collating the law of the sea, today we hear of the word freedom of navigation, a phrase which does not exist in UNCLOS, but it has become a part of our lexicon. It stems from the principle of customary international law under Article 87, within bracket 1A of the 1982 UNCLOS. Thank you for those who have accidentally unmuted. Okay. And in the maritime dimension, quick look. See, this is the complexity when we go into the maritime dimension. The very notion of territoriality and strict boundary lines vanish. And I will not explain, but to say maritime zones are so complex. And what do you tell marine animals? What do you talk of the nature and ecology? How do you define those boundaries? How do you bring strict law? Post-independence, the jurisdiction of admiralty courts in India were limited to the claims as enumerated in the carried forward British legislation. Today, the Supreme Court of India has prepared and emphasized the principles of International Convention on Maritime Laws appropriate in India's common law. And so, just a quick reference, let the slide be there. Admiralty law, it had to come to 2017 before now India has an admiralty law. It's not a work which is complete, but it is a substantial piece of legislation which has expanded the jurisdiction of even high courts beyond just Mumbai. And there are issues related to ESET, which I will take in a case of. So again, okay, let me just skip this. So we begin when we talk of the legislative framework with UNCLOS. We all know about the three conventions, the three discussions, but finally it's a third one. The good thing that UNCLOS did is in section 3, it divided the zones into territorial, continental, EEZ, and other maritime zones. Here is the interesting part. UNCLOS was ratified in 1982. India jumped the gun and made the Maritime Zones Act in 1976. Obviously, it took for granted some of the discussions, and then there are pieces of divergence between the MZI and the UNCLOS. So my paper talks at length, and I'll just talk of these three. Section 15 of 1976 Act talks about jurisdiction over various zones. Section 9 talks about agreements to determine boundaries. Section 4 talks of innocent passage. It's not freedom of navigation. The key word is innocent passage inside the territorial sea of India. And so we have made a, in terms of territorial waters, this 1976 case study, Pride for Armor versus Union of India and others, sorry, 2001 case, exercise and gives us background to jurisdiction onto various zones. And then exclusive economic zone. This is the new beast in international maritime law because it extends to areas where the coastal state has jurisdiction only over the seabed and the waters below, but passage is not permitted. I'm running out of time, so I'll just refer. I have three case examples. Bangladesh and India, 2009. Both approached the maritime boundary jurisdiction under two different principles of equidistance method and equitable solution. Bangladesh was given the in the award, it was their position was recognized, and India accepted in a collaborative framework. Come in contrast to South China Sea, and we know what is happening. I don't think the audience needs to, but each nation is approaching it in different manner, and it's a hotbed of legal and governance issues. These are the disputed islands. All I want to show, China talks of dashed lines. Are you aware the dashed lines in 1940 and 2000 have moved at places by 50 nautical miles? If you are talking historical, how did history move across the region? So there are huge issues where they left present. Case number 3 is a recent brouhaha, which is international politics about USS John Paul Jones sailing close to Lakshadweep Islands. In the MZI Act, India has promulgated that you need a prior notification. The US claims, which is not a signatory to the UNCLOS, says that UNCLOS does not require us to pass through. So there are interesting things in international politics. But as of now, it still requires nations. There are gray zones in jurisdictions in the EEZ. What is the way forward? And this is where is my emphasis, which comes to legal history. With growing complexities in the maritime order, collaboration, coordination, and cooperation is the only way. India's promulgated security and growth for all in the region policy has come into focus, in which Coast Guard and the Indian Navy, even in the recent Cyclone Tokti, where we reached and into the other places for assistance across the region, like India had helped the US vessels when they were passing the Malacca Strait and to Seychelles. The second last slide, India's declared policy is advocating collaborative growth and pace in the region. And just allow me, Chair, for one closing point from what Professor Kalyani says. In terms of archives, let us not bemoan what has happened in the past. Legislative framework, the whole recognizes record keeping. But as Professor Muson said, let's look at history of the future. Let's chart the vision forward. So records from today onwards, can we place it on the cloud? Can we correctly record? And there can be tons of interns. I'm sorry for a wrong collective noun, but many who can sit and work and actually encode what is available. So we finally break the traditions of oral records and lack of records and having to do secondary records. And I believe that will make the All India Legal History Congress a success in the future. Thank you for your piece. If I have violated certain tenets of law and scholarship, as I said, please pardon my insanity of seafaring. I have a wonderful team, those who are keen to study and apply these, and I look for guidance from the panel. Sorry for stealing a few minutes from the young scholars. Over to you. Thank you, Chair.
No, thank you so much, Dr. Johnson, for that, really wonderful reminder of the importance of looking at the seas and also the sort of looking towards the future and methods of archiving, that we can actually implement now. That was really wonderful. And I really hope to be able to visit you at the Maritime History Society in the near future. So moving on to the next paper, we'll be hearing from Sangeeta K, who is a second-year student at the Government Law College, Chengalpattu, and their paper is South Asian Legal History.
Very good evening. First of all, I would like to clarify about my paper topic. With the permission of the committee, I'm sorry. I'm allowed to look east. So my topic is Southeast Asian history. Sorry for the mistake in the paper. So the term Southeast was first used during the Second World War by Allies to liberate the region from the Japanese control. The state lies to the south of China and east of India are called Southeast Asian countries. They are classified into mainland states and island states. In the wake of World War II, many empires fall and many budding nations born with new ideology. The concept of socialism, democracy, and authoritarianism emerged as new manifestos. The ideology, in turn, forms the basic legal structure of each nation. My paper attempts to analyze how far the political history influences the legal history of each nation. First of all, Indonesia. Democracy was not easily achieved. The Republic of Indonesia was born in 1945 after a long period of Dutch colony and Japanese occupation. Like India, Indonesia is also a pluralist state. There emerged many conflicts like communist versus anti-communist, Panchasila versus Islamic states, Santri versus Abangan, Java versus Sumatra. If I'm so very sorry. If we look into the history of the nation since independence, it can be divided into three main groups. The parliamentary period, democracy, which is a failed one because the coalition does not happen. Every cabinet falls one after one. And then the guided democracy period, it is also failed because the political dominance was emerged by the communist PKI. And the period under General Sukarno, who successfully stabilized the stability and order in the name of new order. This political instability directly affects the legal framework of the nations. The country adopted federal government under 1945 Constitution. In 1949, they adopted United Republic of Indonesia, which lasted for just 7 months. If they went, then they went back to their original constitution. The constitution itself was reinstated again and again. Then the Vietnam. Vietnam has a long history of struggle. First against the Chinese subjugation, secondly against the French colony, thirdly against the Japanese occupation, and finally against American military intervention. The Communist Party of Vietnam follows the Marxist Leninism and Ho Chi Minh ideology. By following these, the first constitution of 1946 was adopted. In the year of 1955 to 75, two political regimes was I'm so very sorry for my I'm moving on to the last part. I'm not able to speak just now. My paper's topic is we cannot separate politics from the law, because by understanding the demands and expectations of the people, the legislations are made in a country. So if we want to study legal history or constitutional history of the nature, we have to start with political history that paves way for a legal framework. So Southeast have a common Asian asset. Politically, ideologically, they differ from each other. Indonesia struggle for democracy, and Vietnam's diplomacy to join ASEAN. Philippines' close ties to US, and Singapore's way of bureaucracy. Thailand, a lone survivor. Myanmar's military coup, and Malaysia's constitutional monarch, and Laos' ideological revolution, and Cambodia's civil war are definitely a lesson to India to learn to avoid their mistakes and embrace their advantages. Thank you for this opportunity, and I'm so sorry for not taking so much time. I'm sorry.
Thank you, Sangeeta, for that really wonderful presentation and for encouraging us to look to broader geographies, including Southeast Asia. That's really, I think, adds greatly to our perspective. So I'm going to move on to the next paper, which will be presented by Soumya Sakshi. And there are a second-year student at the School of Law, Christ University, Bangalore. And the title of the paper will be The Genesis and the Nemesis of the Legal Development of South Asian History. So passing the floor over to you, Soumya.
Thank you so much. Is my screen visible to everyone?
It's, oh yeah, there it is. So I think now you'll just want to play the slideshow.
Yeah. One second, I'm so sorry. So, good evening to one and all present here. The title of my research paper is The Genesis and Nemesis of the Legal Development of South Asian History. Before moving towards the presentation, I would like to raise a question to all the audience that, has South Asia ever lived the concept that is propounded by the historical school of law, which says that with the changing need of the society, the law should be changed? I don't want any answers from you right now, but I would like to assure to all the audience that after this presentation, each and everyone will be able to answer this question. Also, because of paucity of time, I would not be able to discuss the whole paper, but I will speak on some very important aspects of the paper. So, the research paper actually revolves around two questions, and those are, what were the loopholes present in the pre-existing legal system that fostered the establishment of the new legal system, and the pros and cons of each legal system? So, we can broadly classify the pre-existing legal system into three parts. The ancient legal system that had two characteristics. First, it was based on divine laws, and the second, it was civil in nature. Medieval legal system. It was based in Shariat laws, and the main characteristic was that the legal system was theological in nature. The modern legal system, which was based in common law, and that is precedents and legislation. So now let's talk about the ancient legal system. So the legal system that was prevailing at that time can be divided into two parts, as they were way different from each other. The early Vedic system used to follow the concept of natural laws, law school, as they believed that the Vedas were given by the Lord Brahma itself. They had codified laws as they created Dharma Sutra and Dharma Shastra for themselves. But later on, in the later Vedic period, the importance of divine law lost its value, and the Indian subcontinent started to walk in the direction of the positive law. The rule that was laid down in Vedas and Dharma Sutra was violated by the king themselves. The notion of king, changed. Earlier, the king was seen as the leader of the clan. However, in the later years of the ancient legal history, the king was seen as a divine figure. So now let's talk about the pros and cons of the ancient legal system. So first, we'll go with pros. The ancient legal system had a strict legal system that hindered crime from taking place. If we see the works of some philosophers of that time, we can see that they believed in strict dandaniti, that is punishment, as Manu goes on to extent of calling dand itself to the king. In Shukraniti also, there was a description of punishment such as death sentence, mutilation of body parts, and confiscation of the property. In Silapaddikaram and Tolkappiyam, it was even described that if a thief is caught red-handed with the stolen good, he was beheaded. So the offenders were punished publicly to set fear in the minds of the people, and these types of exemplary punishment were appreciated. The laws were not compiled in a book and kept in the library. However, it was engraved everywhere on the rocks, on the pillar, and even in books. And the judiciary was very fast in nature, since the judiciary was decentralized and each king, Gramini and Sabha possessed right to decide. So now let's go towards the cons. The Dharma Sutra was constructed by Brahmins. Hence, the laws compiled in Dharma Sutra was not made under the veil of ignorance and thus favored Brahmins. So it was biased in nature. Also, the laws were God-fearing in nature. If we read some ancient books such as Garud Puran and etc., it had certain major punishment for minor follies, which created fear in the minds of the people. So they acted out of fear and not out of freedom. So now let's talk about the loophole. So because of the strict and biased law, people were not loyal towards the lex loci and started to help the invaders. Henceforth, the king of Arabia vanquished India and started to implement their laws in India. So now let's talk about the medieval legal system. The law system was established by the Islamic ruler, and the law did not evolve with the changing need of the society. It was actually established. It was the Islamic laws were ex situ in nature and came with Muslim ruler. The legal system of the Turco-Afghan period depended mostly on the nature of the king, on the religious view of the king, and the trait of the king. For instance, in one dynasty, we found a remarkably tolerant king like Akbar and the most intolerant king Aurangzeb. Now let's talk about the pros. Even the king was subjected to law. There were a lot of contribution by several sultans in the field of justice. For instance, introduction of special type of code for heinous crime. Books were introduced for judicial reform, and custom of submission of reports of lower judiciary to the higher judiciary prevailed. Also, not only they had qazis and muftis, but
Umia,
also,
I'm apologize for interrupting, but I just want you to let you know that you have about 2 minutes left.
okay, I'm so sorry. I'll just summarize it. They did not. I'm sorry. 1 second. Yeah. So I'll just move forward with the cons. So the cons were though they were a separate judicial department, there were no separation of power. The emperor was the head of the department, and there was also the presence of some biased laws which allowed the murderer to escape by paying money to the family of the assassinated person. So now let's talk about the loopholes. The medieval legal system did not have any law to regulate the foreign traders, and therefore they just had to please the sultan, and sultan acted like a credulous child and gave farman for everything. Second loophole was that the laws were not codified, and the lex loci of the land depended on the nature of the king. There was a vacuum created as the civil cases were adjudicated according to the personal laws, but the criminal cases were adjudicated by Muslim law. So this was not acceptable to the Hindu population. So now let's quickly move forward to the colonial legal system. So the East Indian Company came to India with some limited right. They had just a farman of Jahangir and some power given by the legislation. However, gradually the company got judicial powers too, and they started to pronounce judgment for India with their whims and fancies, because at that time the judges were not learned in law; they were just merchants. Later on, by bringing chatter after chatter, they started to rule with the laws of England. Subsequently, they codified the laws. So now let's move towards the pros of the colonial system. By the section 53 of the Act of 1833, the Law Commission was appointed with the Lord Macaulay as its chairman. It gave the Lex Loci report, and on the recommendation of the Law Commission, the Indian Contract Act of 1859 and IPC was enacted. So now let's talk about the cons. So certain precedent that acted as a black stain in the history of the Indian system. One of them was the trial of Nandakumar, the Patna case, the Kosi Jora case, and also one Asentia Dawes case, as I remember. So even the jurisdiction of Supreme Court was not defined properly because there were existing of two acts, that is Regulating and Settlement Act. So there was no division of power at that time. Also, there was a fight between the government of council and the Supreme Court, and also the law favored white people. However, the most unjust thing which was done by the colonial government was imposing fine in the process of justice seeking method. The justice is supposed to get freely, and it is the duty of the king to give it freely. So this was it. And in conclusion, I just want to say that that each existing legal system played an important role in maintaining in making the present legal system better. Out of the three, one was in situ and the other was ex situ. Each one was unique and both has pros and cons. Thus, answering to the question raised, India in past did not see the evolution of law but establishment of law. Thank you.
Thank you so much, Soumya. That was really wonderful, and you covered a lot of ground, and I apologize for having to rush you a little bit. So finally, our last paper will be from Niharika Ravi, who is a first-year student at the SVKM's MIMS School of Law in Mumbai. And the title of the paper will be A Socio-Legal History of Bharatanatyam in South India and its relevance to intersectional issues in South Asian legal history. So without further ado, over to you, Niharika.
Thank you. A small clarification. I'm actually a second-year student from NMIMS. There was a bit of a typo there. Please allow me to share the screen just a second. Is the screen visible?
Yes, you just need to play your slides now.
I'm actually unable to do that. I think we'll have to make do with this because I'm
that's absolutely fine.
All right, thank you. So once again, good evening, everyone. I'm Niharika Ravi, a second-year undergraduate student from NMIMS Navi Mumbai, and as ma'am just stated, my paper is titled A Socio-Legal History of Bharatanatyam in South India and its relevance to intersectional issues in South Asian legal history. My paper begins by asking a fundamental question, which is what is history? And it looks to renowned historian E.H. Carr's definition of history, which says that history is a dialogue between the present and the past. And it is evident from cave paintings from around the world that dance has traveled across time from the past to the present. And it has in fact been witnessed to both these periods in time. And in fact, Indian dance has evolved in this time from humble folk origins to nuanced classical forms that draw legitimacy from what are known as shastras or holy texts. Now, most shastras underwent reinterpretations over the centuries that arguably diluted the essence of the text and created certain socio-cultural evils that pertained primarily to caste and gender-based issues in the country. And these issues pervaded dance culture in South India around the 12th century AD. These issues further subsisted in the fabric of society in many ways beyond the 20th century, when the alienation of dancers from their art retrospectively became a major socio-legal concern in South India, and by extension also in South Asia. This presentation shall focus primarily on caste and class-based issues within dance, because gender in dance is a widely researched area, because the Devadasi system is a great commentary in the history of gender in society, as Professor Elizabeth outlined this morning in her address. This paper indeed is centered on the historical fall of the Devadasi class at the hands of its erstwhile spectators, turned critics, turned social excommunicators. And this is the history that I hope shall one day be sensitively taught at a very large scale, at least to students of dance, not just in India, but as a part of the South Asian diaspora across the world, because it still affects Indian society in major ways. Now, before delving straight into the social implications of dance history, it is essential to note what the sociology of dance did to its history. And it is apparent that a mythological history with fantasies of gods and demons has been created to veil the real history of the art. This mythological history is conveniently attributed to a slokam from the Natya Shastra, which is called the Natya Utpatti, or the origin of Natya or dance, which traces down the origins of dance back to the divine. And many stories have been woven around this premise since then. But actual history points to the fact that the art has emerged from previous forms like Sadar, Noch, and Bhagavata Mela Natakam. And the Devadasi's art is said to have been born in the Keshari dynasty in the 6th century AD. And it is then on that the Devadasi sect was accorded perhaps the highest status in the temple, until theoretically plunderers looted the temples and rendered the Devadasis homeless, forcing them to resort to a trade that the sect never really recovered from, prostitution. After this, they were periodically subjected to prostitution at the hands of priests, kings, and noblemen, who ensured that a myriad of laws were passed to oppress the Devadasi sect and to force generation after generation of Devadasis to become prostitutes. In the 20th century, social activists who belonged to upper castes and classes took it upon themselves to institute a movement to save the art from extinction, and hence reformed it in many ways to make it suitable for higher society. This movement, the anti-Noch movement, is what we focus on here on. Moving on from the brief history lesson, Bhagavata Mela Natakam, which is one of the folk forms that Bharatanatyam is said to have originated from, was performed entirely by Brahmin men. Bhagavatas represent one school of dance tradition with their sacred dramas, but the lower caste Nattuvanas and their pupils, the Devadasis, are said to represent another. Parallelly, the Tanjavur and Kalakshetra schools that emerged in the 20th century were also segregated on the basis of caste. Caste divide can not only be seen in the art in this segregation, but can also be noticed in the movements and the pieces. The Tattajatiya Hastas, which teach every student of dance to portray the 5 castes, refer to the outcast or the Shudra literally as a Rakshasa or a demon, a quality that is also attributed to every Adama Patra or evil character in the Natya Shastra, who is almost always depicted as a lower caste or class person, demonizing people from these social backgrounds. Caste discourse is also found in pieces written by Mudaliar and composed by Gopala Krishna Bharati, contradicting the Natya Shastra's commandment that dance must be used simply to create beauty and festivity. Perhaps dance can be used to create social awareness as well. A very interesting angle of the notions of purity and pollution emerges herein that I'll touch upon very quickly. And potentially, this idea can perhaps be compared to M.N. Srinivasa's discourse on Varna. The Devadasi, who was accorded the high status in perhaps before the 12th century, was considered pure, but she became impure or polluted when she was prostituted. A subset of the mythological history that was perhaps devised many centuries thereafter speaks of prostitute Devadasis who were employed by pure Brahmins because they begged them to be rid of their polluted lives. Sadly, life seems to have come a full circle for the Devadasis when they were prostituted by the Brahmins themselves once again. And the polluted Devadasi culture was supposedly combated by the anti-Noch movement. The anti-Noch movement itself originated from the upper caste.
Sorry to interrupt. I just want to let you know that you have about 2 minutes.
All right, thank you. The anti-Noch movement itself, as I was saying, originated from upper caste and class citizens' interactions with the British. And not only did these Indian elite attain an English education, they also came to absorb Victorian moralities that they saw around them. And these were vastly different from their Indian roots. Since they were the first interface with the English and their criticisms of the Devadasi system, criticisms like the Madras Devadasi Prevention and of Dedication Bill, which was passed as early as in 1938, they came to realize that there was an inherent contradiction in the fact that they were tolerating the Devadasis, or rather even courting them. But these Devadasis were seen as the British as trumpets who would open their cells to infamy as soon as public business was done. This is what forced the upper caste elite to try to legitimize the art, and in trying to do so, they first distanced themselves from the Devadasis, then tried to defame them, then stole their art, and further attempted to erase them from history after isolating them completely from society. It is ironic that this process is called the revival of Bharatanatyam. The very name Bharatanatyam became a marketing tool. It distinguished the new art from its older taboo origins. Those who made changes, like Rukmini Devi Arundale and lawyer E. Krishna Iyer, came to be regarded as the saviors of Southern art, And suddenly everything from the sensuous aspects of the repertoire, the jewelry, the musical instruments, and even the clothing, everything was changed. It is thought that these artists expected that the art would eventually trickle back down to the lowest rungs of the society in its reformed identity. But the status of the Devadasis today, that we know all too well as a sect that is only attributed to prostitution, sadly it begs to differ. In gender narratives that seek to demonize the sexual agency of the Devadasis, it is important to recognize that in their earliest sexual exploits lies one of the greatest feminist accounts in South Indian history. The Devadasis' free agencies over their own bodies is a prodigious statement to the power that must not be languished in history at the hands of a pejorative colonizer-pleasing narrative, which is the anti-Notch movement. The Devadasi community in the 21st century is completely isolated from the art. The community's goddess Yellama is someone who these young girls are dedicated to, and then they are pushed into a life of prostitution. And this was a fate that was written many decades ago by these educated upper caste elite. A last question to answer before I sign off: how does this woeful tale relate to South Asian legal history, which is the theme for the evening? Bharatanatyam is a global art form in the 21st century, and indeed it has been so since, well, the 19th century, when Rukmini Devi and Bala Saraswati began performing abroad. Today, the South Asian diaspora around the world practices Bharatanatyam. The NYC Adavu Collective and Indian Raga are prominent examples of this phenomenon. The origins of the art and its social-legal implications must not be restricted to India anymore. These histories must reach out to dancers across the world and must come back to truly trickle back down to the Devadasi sect, maybe in its globalized form, but maybe also we should give them an opportunity to revive an art that originally belonged to them. Thank you.
Thank you, Niharika, for that really wonderful presentation. And I'll just on a personal note say, I think you're absolutely right that we need to think about histories of Bharatanatyam in diasporic context. I live in New Jersey, which you may or may not know has a huge South Asian diaspora, and my mother-in-law is already putting pressure on me to enroll my 2-year-old daughter in Bharatanatyam classes. So, I think that's a perspective that we haven't really gotten on the dance form that, your research could really help to enrich. So I think we're going to move on to the discussion part of the panel. We've heard from 5 really sort of wonderful speakers, and I hope that the discussion can kind of pull some of the strands together. And I think as I'll take the prerogative of the chair to say, I would really love to start with a question from a student, either one of the panelists or one of the students who have joined us as an attendee, and then we'll move on to kind of open to anyone. But I've been so impressed by the student presentation, so I would love to hear one of the students engage with the papers. To ask a question, you can unmute yourself and ask it in person, or you can use the chat if you don't have access to a microphone. Niharika, did you want to ask a question?
Yes, thank you.
Excellent.
I want to ask Professor Ramnath if she has any ideas. We saw those images of the Madras, the documents that are stored in the Madras High Court, and I want to know if she has any ideas of how perhaps students of law or the legal community can work towards maybe systematically storing those documents so that the legal community can have better access to them, something along those lines.
No, absolutely. Thank you, Niharika, for that question and your wonderful suggestion that there should be more involvement by the profession and by law students in sort of preserving the archival records of the Madras High Court. I absolutely did not mean to indicate with those images that there is something that's terribly wrong. As I said, this is a working part of the court. It's not a traditional archive of the sort that where you go into the Tamil Nadu State Archives at Egmore, for instance, and that has a very different function, and it is organized on very different principles. However, just the magnitude of cases that come to the Madras High Court from all over the state, not to mention the fact that before the linguistic reorganization, there's also records from all over South India that are stored there. What can we do about it? I think there should be an explicit recognition, perhaps possibly championed by universities and supported by the legal profession, the bar council, so on, that this is also heritage. There is a lot of emphasis on preserving the architectural integrity of these wonderful buildings, and there's a lot of effort being channeled towards this. But the paper, the archives, the records, that is also our heritage. And so I would love to see, perhaps, I mean, honestly, the starting point is that recognition. Once that's done, perhaps if we could have a panel of experts, scholars, and students come together to maybe decide, let's tackle a small part of this and see if we can bring about some kind of systematization. Excuse me. This requires expertise. This is not a job for people who don't have expertise in archival management. There are plenty of those in India. This is not something that you need to, you just need to recognize it. I think that's, I'm really heartened to hear that there is student interest in doing this, because I think it's so important. As you perhaps got a sense of from my presentation, imagine the histories one could write with those records. Just imagine. I'm just really excited by this possibility. So let's be in touch.
And I think Dr. Johnson also has something to add on this important topic.
Very briefly, in fact, as soon as Professor Kalyani had shown those records, I mean, something just went off inside me and kind of, but just to specifically answer Niharika, one of the challenges in archive management has been the focus has been overly skewed on the material management and on the preservation, which means actually take it away from anyone who needs it. And any archive you go, there is more effort how not to give you the archive rather than how to give you. And so that's why I said, as we go forward, the focus on the content is the least. And today we have so much of tools available where even if 10 students can just take one file and just do one internship, we have that record permanently digitized. So I'm just giving a small part, and this has got nothing to do with legal history. It is, we in our region, we are poor in recorded documentation by history. There is a revival of oral history of India, but unfortunately, content across is a weakness. And I think tools and modern ideas, I am ancient in some of them. I think current and modern ideas of extracting the content will be a great service. And yes, professionals must be the drivers to this. Thank you.
That's wonderful. And I just want to echo Dr. Johnson's comments that, I think there's a huge role for young people, for students to play in these processes. You guys know the most up-to-date technologies, innovative ways that we could both preserve the documents, but then I think, as Dr. Johnson is saying, the most important thing is that we actually get access to these contents and not just the physical records, but what's inside them and ways to think about them in creative ways. And I think, students have a really important role to play in that process. So I'd love to take another question or comment. And I'd welcome, any of the panelists can also ask questions of the speakers. I have some comments of my own, but I want to make sure to give anyone who wants to speak to the contents of the papers a chance to speak. I guess then maybe on that note, I'll kind of offer, you know, a few synthetic comments and observations, and maybe that will generate some additional discussion. So, you know, I first want to echo others in thanking Professor Elizabeth and Professor Stalin for organizing this conference. I mean, it's really remarkable that they have been able to pull this off, particularly given the wider context of the pandemic, and in a time in which all of us are faced with, you know, such deep, you know, personal tragedy. You know, actually attending this conference has sort of given me, you know, a little glimmer of hope of the kind of new possibilities that are opening up for us to kind of collaborate at, you know, wider geographical scales through tools like Zoom. And of course, this panel really speaks to thinking about India in sort of wider regional contexts. And I thought it was really refreshing to think at these sort of in these alternative geographies, whether it be South Asia, the Indian Ocean, or even kind of global contexts, you know, when, you know, still much of the legal history of India has been written in a kind of nation state form. And the other thing I observed in sort of reading the papers before the conference was that often this move towards wider geographies went hand in hand with thinking about alternative chronologies. So many of the papers took much more longue durée, or, you know, that's a fancy French word, but sort of, you know, took, you know, millenniums as their sort of chronological scope. And I think that these alternative timeframes sort of do go hand in hand with thinking about geography in broader terms. But I think, you know, particularly for the students, you know, you may have in your work encountered that embracing both a big geography and a very long timescape presents challenges. You know, how do you find a kind of approachable research topic in which you're covering, you know, such immense ground, especially when you have to give a presentation that's 5 to 7 minutes long. And so I wanted to sort of suggest, you know, picking up on strategies that were employed in both of the faculty papers, that one of the ways to do this is to kind of pair these broad perspectives with sort of more manageable narratives. So we saw that Professor Ramnath used sort of histories of particular cases, of particular individuals, of smaller diasporic communities to kind of chart a path through the very expansive geography in which she's conducting her research. And similarly, Dr. Johnson, towards the end of his paper, he lays out 3 case studies. And again, this is another way to sort of tackle these very, very large topics through sort of more manageable sort of research, where you can really conduct kind of original research at a scale that's practical from a kind of, you know, human set of capacities. And I saw a lot of potential in the student papers for further research that might take this approach of sort of pairing the very broad perspectives that you're offering in your papers with sort of more focused case studies or micro histories. And I particularly just, you know, I could cite examples from all 3 of the student papers, which were all wonderful, but for the sake of time, I thought I would just sort of pull out one from Niharika's paper, which I was just absolutely fascinated by your short sort of reference to Sri E. Krishna Iyer and his work, both as a lawyer. It's fascinating that he's a lawyer, then as also as a social reformer and the head of this anti-Nach movement. And I think, you know, absolutely there could be a wonderful MA thesis there, you know, looking at his biography and using his biography to kind of think about what is the relationship between sort of social reform and the law, and the particularly like interesting dynamics of gender that are at work there. I mean, you sort of mentioned in your paper that he actually would dress up as a woman in order to engage in these sort of purist efforts to purify Bharatanatyam. And that's just, as a historian of gender and sexuality, that's just completely fascinating. And I would love to kind of learn more about that. So I think, you know, in terms of thinking, you know, how do you take these like broad interests that you've charted and then transform them into projects I hope that you all might pursue in sort of graduate training, either at at the MA level or at the PhD level, I think it's, pairing these broad perspectives with these sort of case studies, micro histories, and I think law offers, perfect models, because of course that's what we always do when we study law. We're pairing this kind of broad perspective in which we're looking at the development of law over extensive sweeps of time with the focus on particular cases. So that would just be sort of my research recommendation. But again, I just want to say that these papers were, enormously rich, and the format of this conference, I think, really suggests ways to move forward in, the legal history of South Asia is being written, in multiple parts of the world. And I think we can use tools like Zoom to kind of put us all into kind of greater contact with each other. So those are my thoughts, and I would, welcome comments, either from Professor Stalin or from Dr. Johnson or from Dr. Ramnath, if you have anything to add to that in terms of, pulling together various strands of the papers.
May I just add and just echo what Professor Julie said, especially for the student participants, don't stop. Don't stop. It doesn't matter what happens. And what we have done in our setup is we have focused on something called, I'll borrow the word microhistory, and I'll say we said micro research. Even if you have to just write 500 words, 1,000 words, the basic methodology does not change. The volume of research might still be phenomenal and months before you are able to pare it down to just those 1,000 words. So that's my encouragement. That's what we have been doing with our young scholars. In fact, the first few months, they only have to just write 200 words each day. Just keep writing, and I think it'll come. And these are beautiful. Thank you, Professor Julie, for my people who are attending to get those research tips. They're very handy. And of course, Professor Kalyani has opened up a whole lot of things. I'm looking forward for the full paper, full context, and use it as a case example. But I just say, sorry, I can use a little age and say blessings for actually turning this opportunity, legal history, and what Professor Massons mentioned, it doesn't matter whether you're from the field or not, as long as you have interest in the field. Yes, it's preferred to be legal scholar. It's preferred to have a historical background, but that doesn't restrict. Like you took Nehari's example, if someone has studied dance, they could always probe that angle. So I think fantastic opportunity. I'm just honored. Thank you, Professor Stalin, for the continued opportunity.
Can I just add just one line to both your comments, which are truly, really insightful. And I tremendously enjoyed listening to the student papers, took me back to my days teaching in India. But I just wanted to add also that we don't need to restrict the study of legal history just to the writing. There are also new genres and ways of presenting this material that are not restricted to a research paper. So, a lot of digital bond material is now being presented. You can work in conjunction with artists. You can think about capturing oral history. You can think about doing graphic. I mean, there are so many different forms that we can use in order to experiment with how legal history is not just written, but also presented. I really am, and this is really where a lot of student energy can just be so productively used because you have access to some of these things that we are perhaps a little more distant from. So think creatively, think outside the box, think of ways in which, this is really a history of the now. I mean, legal history it just is in the past, right? It's always in the present, as your papers showed. So just an invitation for you all to go forth and think of imaginative ways to do this work.
Yes, Professor, by adding to this, so we always encourage our students to come up with a different research work. They always think differently, so that our presentation, out of 60 paper presenters, most of the papers, around 40 papers belongs to our students, even starting from first year students to postgraduate student, and there are there is one MPhil graduate and teaching faculties, and there are very few numbers, but we encouraged more from student side. And they to come up with a different idea, as you suggest, they always thinks out of box. So they have to come out very different idea. The title, when you have time, because you please go through all the paper presented and in different section, and very innovative title and very different title. We were really surprised to have the different papers from different scholars across the country. This for your information. We always give importance to the students to think independently, to think out of box always, especially TNNLU is provide a lot of research area, and we give complete freedom to students to think in their own, to come up with a different research area with the guidance of our teaching fraternity. So this is my side. So congratulations to all the paper presenters. And I already met Commodore Johnson last year in Gujarat, and we are really happy and delighted to get paper from our Dr. Commodore. Okay, thank you very much, sir, for your wonderful contribution and continuous support to our Legal History Congress.
Yes, absolutely. Thanks to everyone, and particularly for taking the time to present, while many people are, struggling with the pandemic. It's really, really impressive.
So I extend my wholehearted thanks to our lead speaker, Professor Kalyani Ramnan, and our chairperson, Professor Julia Stephen, and Dr. Commodore for his wonderful support and continuous support, and all the paper presenters, starting from the students Sangeeta, Soumya Sakshi, and Niharika from different parts of the country. And thank you very much for your wonderful contribution. And thank you very much for spending your valuable time with us, Dr. Kalyani Ramnath, as well as Dr. Julia Stephen and Dr. Commodore. Okay, thank you very much. And a very good morning to you and good evening for all of us. And I extend gratitude to all my colleagues who have joined here. And there are Dr. Vishnu Prasad and Professor Mahendra Prabhu and Ms. Ammakanu and Dr. Subbarao and other participants and delegates. And I wish them very good evening. And thank you very much for your active participation in this Congress and your favorable support. Thanks, one another. Thank you.
Thank you, Dr. Stalin.